Well, welcome back, everybody, to another edition of the Law Sunday Side Up. I'm Joe Costello, Chief Assistant Prosecutor. Our elected prosecutor is William Nichols. We have a great guest in the studio here today. We have retired Judge Michael Labeau, who just recently retired from the 38th Circuit Court. And retired Judge Labeau, welcome to the program.
Thank you.
And I was thinking back into the early 1980s. You had a law clerk that worked for you when you were a prosecutor, and that was myself. And I want to thank you for that opportunity. But as I think back in those days, you realize all the future judges that came through your office?
Oh, I know. It's really amazing. I had an intern program at that time. Prior Judge Moskwa, who's now retired, as you know, was an intern. Judge Jack Vitale, the now Monroe County Chief Judge, was my chief assistant for a while. After that, Judge William Lavoie, who's now retired, was my chief assistant as well. I had former prosecutors in my office, many really good attorneys. I can't think of any other prior judge. Oh, Judge Brownlake.
Mark Brownlake.
Mark Brownlake. Almost forgot about Judge Brownlake, who actually I should not have forgot about him because he took over my place on the circuit court bench.
And Dan White.
Correct. Dan White was also an intern, and he's on the circuit court bench. So that's a number of people.
I'm telling you, you must have the golden touch back then. So, yeah, a lot of people came through the office. Well, I was talking to you before we came on the program today and seeing you in a suit and tie. I asked you, what's it like to wake up in the morning now, not to put that suit and tie on every day?
Well, as I told you, it was very nice. This is only the fourth time since June that I've had a suit and tie on. And I don't know if my neck got bigger or the collar shrunk on this shirt. I'll probably be wearing a suit and tie more often in the future, however.
And that's a good segue into what we're going to talk about today. So, with all those years on the district court, all those years serving in the circuit court, we certainly recognize the fact you were a prosecutor before that, a district court probation officer before that. So all of that, I know that you took a training, and was that through ICL, the Institute for Continuing Legal Education?
Correct. That was mediation training through the Institute of Continuing Legal Education. I took that about a year ago.
And that was like a 40-hour program, a rigorous program, and I'm sure other lawyers, and I don't know if other soon-to-be retired judges took it with you, but I know a lot of lawyers take that, because we're going to talk today, folks, about something called mediation or case facilitation. And mediation is an opportunity for parties in a lawsuit to get together to see if they can settle the case. And rather than take their chances either with a judge or jury, not knowing what the outcome might be, and to have a little bit maybe more control in how that case comes out, they can go to a person that's been trained and to try to mediate their differences. So I understand you've hooked up with one of the more prominent law firms here, Leonard, Graham, and Goldsmith, and that's where your office is going to be. Is that correct?
That's correct.
And if anyone wanted to get a hold of you, I think they can reach you at that number, 242-9500. Is that also true?
That's correct, and I also have an email address, which is mlabeau1776@gmail.com.
Okay, so if someone wanted to arrange to have you mediate over a particular case for them, they could reach you at either of those, the number, that email address.
That's correct.
And certainly there's always a cost to this, but far better to spend money on a mediator than trying to spend maybe hundreds, if not thousands of dollars on litigation. And in the end, you might not like the outcome, but at least with mediation, that's probably the beauty of it, is it's not binding. Isn't that true?
That's correct.
And I think that's really the best of both worlds. You have a shot at settling the case, and if you don't like it, you don't settle. And so what was that training like? What was that 40 hours of training like?
Well, initially they go through the law, the court rules. They have the instructors go through sample mediations. You watch them do a mediation. Eventually, you end up doing mediations yourself, and you're graded on how you did in the mediation.
And were you the only judge that was in the program at that time?
At that time, but there have been prior judges in the past that have taken that program, and I don't remember if you did at one time or not.
When I took it, I don't remember there being other judges either. But boy, they really gravitated to me there because they thought, oh, I'm going to hook up with this guy and start a mediation practice. And as you know, I went to the prosecutor's office, so I'm not doing mediation. I have to think, though. I'm going to call you Judge. As they say, once a judge, always a judge. But Judge, I have to think that all those years of you presiding over all those protracted civil cases, I mean, that probably gave you better experience. I know that you need to go through that training. You want to be certified in that, but boy, that had to be a real piece of cake for you.
It was. As you know, judges handle settlement conferences, and that's when we talk with the lawyers, we go back and forth with the attorneys and attempt to get their case settled before they actually have to have a trial. So it's very similar to mediations. The only difference that I can see is that as a mediator, I will spend time with the litigants as well, but as a judge, I did not do that. I generally did not do that.
Right, because you had the attorneys in your chambers and you tried to sort things out, and there was a lot of going back and forth between the lawyers and their respective clients. So now you'll have the people actually sitting there. Now, one question that our listening audience might have, what happens if they just absolutely can't stand the other person? They can't be in the same room with them. They're upset about this litigation to begin with. Is there a way to mediate where the parties aren't in the same room at the same time?
Oh, absolutely. You just make sure they're separated in different locations. And the office I'm going to be in, we have 3 conference rooms. I'll have my own office as well as a waiting room. And so there's plenty of space to keep people apart.
And, I forgot to mention that although we said the number 242-9500 at Leonard Graham and Goldsmith, you can also find them at 222 Washington Street. They're right there on the corner of Washington Street and 3rd Street in downtown Monroe, right across from the jail, actually. Very beautiful office building. And you won't have to worry about parking. You've got all sorts of ample parking there as well. So I know this is something I know you planned ahead. I think you were taking these mediation classes before you actually left the bench, so you're ready to hit the ground running.
That's correct. I didn't know when I was going to retire, but I wanted to take that class just to get it under my belt because I knew eventually I would want to do mediations, and so I took the class last year.
And so let's say someone says, well, why should I try mediation? I mean, what's the biggest selling point? We've mentioned some of them already, but from your viewpoint, what do you think if you had to tell someone this is why you want to try mediation?
Well, there are a lot of good reasons for mediation, but I think one of the most important ones is that the litigants will have some control over how the case ends. And that is important. Otherwise, they're going to have a judge or a jury who knows very little about them decide their fate on a particular case. This way, they can have input into how the case actually gets resolved. And that's, I think, a big advantage for people.
And of course, your experience with trials, we know that sometimes witnesses don't tell the truth. Sometimes witnesses don't show up or can't recall things. So that can affect the outcome of a trial as well.
That's true. And you never really know what a jury might do. A jury's made up of many different people in the community with their own perspective on how things should get resolved. And so it's really somewhat of a gamble when you go to trial.
And I know when people are paying $3.50 or so for a gallon of gas and whatever they're paying for a gallon of milk, when they think about paying for a mediator, at first they might be, I don't know, they might be a little shocked at what an hourly rate's going to be. But when you think about the hundreds, if not thousands of dollars they'll expend and not have any control over the outcome, it's really a good bargain in my opinion. So what might someone expect to pay per hour if they were to take advantage of your services?
Well, I am going to be charging $250 an hour. And actually, that's somewhat of a bargain rate compared to what's being charged in Wayne and Oakland County. And most of the mediators up there charge $350 and upwards of that. I know of some mediators that charge $500 an hour. So I felt that $250 was reasonable for this community, and so that's what I intend to start charging.
And then how's that paid for? Is that something that's evenly split between the parties?
Exactly. If there's 2 parties, they would split it in half. If there's 3 parties, they would split it by a third. So it's and there's actually a court rule that says that the mediation is to be paid for equally by the parties.
And of course, depending upon the facts and circumstances of a case and really the posture of the parties, there's really no way to estimate how long that mediation might take.
That's correct. I will usually schedule a mediation or at least block out enough time for 4 hours. Hopefully it won't take that long, but some will take longer. One of the things I will do is ask the attorneys to let us know immediately if they anticipate it's going to take longer than 4 hours. Some mediations could take a couple of days. It just depends on the complications in the case and things of that nature, and how many parties, of course, too.
And so usually I'm going to guess that the attorneys are the ones that are initiating this contact with you. If the attorneys are involved, they're the ones that are going to be contacting you.
That's correct. I would be contacted by attorneys who would ask me to do a mediation for them. It would not be the individual litigant. There could be, I suppose, a rare case where there's not an attorney involved, but I would say 99% of the time it will be attorneys who would actually hire you to do the mediation.
And unfortunately, for those that have been involved in litigation, they know how long it takes and how costly it can be. And you, as a judge, a former judge, you remember all those wonderful motions for summary disposition that you had to consider. They would come in inches, stacks high. I remember you asking me when I left the bench and went to the prosecutor's office, and we'd come in to talk about a criminal case, and I would see stacked behind you in your chambers these civil cases, and I could guess that those were motions for summary disposition, which is an opportunity for someone to say the other side's case is so weak that by law or other the fact there's not enough facts, they're going to win summarily, and so it might never get to trial. Therefore, it may never get to a mediator. But I imagine you probably already have some cases lined up.
I do. That's correct.
And just how bad do you miss those motions for summary disposition?
I don't miss them at all. They're an important part of the law, because if a case is so weak that should not go to trial, then the parties and the attorneys should be able to approach the judge and say, Judge, this case should not go any further. And that's important. However, they are very time-consuming, and they are a lot of work for the judge and the lawyers, of course.
They are, and of course that's not the end, because if someone's unhappy with that, they can appeal that. So that's
correct.
Right, and so it's another lengthy part of the process, again, part that adds to the cost. How do you plan on doing this? So when you're doing your mediations, is this something that the attorneys will normally be right there with their clients?
Yes.
And anything that's said there, now this is something probably someone would want to know. Why would I go to mediation and make some disclosure? Can that be used against them at trial?
No, there's a court rule that states that anything said or done during a mediation is confidential. There are some exceptions. For example, if someone threatened someone physically or something like that, and it ended up in some type of a criminal prosecution. But for the most part, everything said in a mediation is confidential, so that it could not be used against them at trial. And it's important for the mediator to advise the parties of that. The lawyers would know that, but the parties may not, and it's important to tell them so that they'll feel comfortable and be open about trying to settle their case.
Right. We want full disclosure. That way we can reach an agreement. And again, I think you're going to be very, very well equipped to do that, again, based upon your experience, both as a longtime judge and all the training that you've received through the Institute for Continuing Legal Education. Do you have any cases set at this time? I don't want to hear about names, but...
I do. I have a third-party negligence case, an automobile case that's scheduled in a couple of weeks. That'll be actually the first one I'll be doing. I did a mediation when I was still a judge, but it was a case that I was no longer going to be handling, and I offered to help the parties reach a settlement. Of course, I couldn't charge anything, nor would I. I was still on the bench.
Right.
And I was happy that did get settled. It was a very difficult case to settle. I now will be starting doing that privately, of course. And I actually had 3 of them scheduled in the next couple of weeks, and one of the cases settled before it got to mediation, and the other one, summary disposition, was granted by Judge Weipert. So as a result, the parties did not get a chance to try to settle the case themselves.
So, well, this has been former Judge Michael Labeau here at MonroeCountyRadio.com today. We want to thank him for coming into the program. It's also good to see you.
Good to see you, too.
And you have to practice on your golf game now.
It needs a lot of practice.
Well, you're going to have time to do that. You certainly deserve that. If you wanted to reach Michael Labeau for mediation services, he's now with Leonard Graham and Goldsmith at 222 Washington Street, 242-9500. And if you could give us that website again or your email address.
mlabeau1776@gmail.com.
Thank you. And thank you for being on the program. This has been Joe Costello, Chief Assistant Prosecutor, inviting you to listen each and every day here at MonroeCountyRadio.com. Tune in Sundays at noon, Tuesdays at 7 o'clock at night for another edition of the Law Sunday Side Up. I hope you have a great week. Thanks for listening in. We'll see you next Sunday.